Hello all. So how was your paper? Paper was moderate paper. If you have good conceptual clarity, you can score very good in this paper. So we'll go with set B of the paper. The question number is 51 and I'll be taking polity and IR sections of your paper. So question number 51, he says consider the following statements. Okay, and the first option is panchayats at the intermediate level exists in all states. Like always, it doesn't exist in all states. Doesn't exist in all states. See, the exceptions are intermediate level to be constituted in states which has above 20 lakh population. Okay, so we'll go down. Okay, and read the second option. To be eligible to be a member of panchayat at the intermediate level, a person should attain the age of 30 years. Okay, and third is Chief Minister of a state constitutes a commission to review the financial position of panchayats at intermediate level and to make recommendations regarding the distribution of net proceeds of taxes and duties leviable by the state between the state panchayats and intermediaries. Come to the explanation. It says, see, the 73rd Constitutional Amendment, 1992. Okay, while mandating panchayats. So when do we need an intermediate level panchayat? Whenever the population crosses 20 lakhs. And the population is obviously not in the state of Dadra and Nagar Haveli, Daman and Diu, Goa, Lakshadweep, Manipur, Puducherry and Sikkim. Which means there is no intermediate level in all these areas. So first option will go wrong. Okay, come down. The minimum age required. See, the Panchayat Raj. See, the Act did not specify different age categories for different levels. Okay, it just said 21 years as a standard criteria. 21 years as your standard criteria. Okay, the third option is it is not the Chief Minister but the Governor to constitute a financial commission which will decide how much of proceeds should be shared between the state government and the panchayats. Clear? So the answer will be 1 is wrong, 2 is wrong and are not correct. So all 3 are not correct. All 3 are not correct. Okay. Come to the next question. Next question is, consider the following statements about Lokpal. See, the topics which are given are very familiar to us. Okay, but he has gone a step deeper. So, I would advise you to read Bare Act of Constitution. And whenever you are reading about a topic, go a step deeper. This is all kind of mains answers which are given and framed as statements. Okay, come here. Consider the following statements about Lokpal, and he says the power of Lokpal applies to public servants of India but not to Indian public servants posted outside India. Okay, come to the second option. Chairperson or member shall not be a member of parliament or member of legislature of any state or union territory, and only the Chief Justice of India, whether incumbent or retired, has to be the chairman. So there are 2 things in this option. First is the MLA or MP of any state or UT can't be a member of chairperson, member or a chairperson. And second, for chairperson, he exclusively states that only the Chief Justice and not Justice also. Only Chief Justice can be a chairperson of Lokpal. Okay, come down. And the chairperson or a member shall not be a person of less than 45 years of age. Okay, there is the age criteria also given. Come to the fourth option. Lokpal cannot inquire into allegations of corruption against a sitting Prime Minister of India. Okay. Come now to the explanations. The explanation says, see, Lokpal Act applies to public servants both within and outside the country. First option is wrong. The second option, definitely the Lokpal shall consist of a chairperson who is or has been a Chief Justice or has been a Judge of Supreme Court or has been a judge of Supreme Court also, not just Chief Justice, but a judge of Supreme Court can also be a chairperson of Lokpal. Okay, and come down. This is true. This thing, the chairperson or a member shall not be a member of parliament or member of legislature of any state or union territory. That's correct. Come down. And a person of less than 45 years of age is also correct. So only and about the Prime Minister's jurisdiction, yes, Lokpal includes jurisdiction and corruption cases of Prime Minister are also covered under Lokpal. But there are few exceptions to it. What are those exceptions? Allegations of corruption relating to international relations, security, public order, and atomic energy and space. Unless and until Prime Minister is under these things, okay, Prime Minister can be inquired into by Lokpal. Okay, so the answer will be 3 only. 3 only. All are incorrect. Okay. Consider the next question, 66th. Okay. Consider the following statements with regard to pardoning power. See, again a familiar question, but he has again gone a step deeper. See, pardoning power of the President of India. And the option 1 says, exercise of this power by the President can be subjected to limited judicial review. See, he has not said, he has coined a word literally like limited judicial review. Okay, come down. The President can exercise this power without the advice of central government. Without the advice of central government. And the explanation will be, see, what is the pardoning power of President? Okay, so yes, see, usually in Constitution it is written that the President's decision will not be inquired into by courts, but there are exceptions. It can be inquired into court if there is a malified intention. If there is a malified intention, hence it is called limited judicial review, and this will be a correct option. Come down. The President can exercise the power without advice of central government. This is not correct. He is bound by the advice of the cabinet, which means central government. Okay, so option 1 only. The option would be 1 only. Come to the 67th question. It says, consider the following statements on the dissolution of House of People. On the dissolution of House of People, the Speaker shall not vacate his or her office until immediately before the first meeting of House of People after the dissolution. Okay, so it says Speaker will not immediately vacate the office after the dissolution, but he continues till the next house sits for the first time. Okay, come down. According to provisions of Constitution of India, a member of House of People on being elected as Speaker shall. That means it is a compulsory provision. He says, from his political party immediately. Okay, come down. The Speaker of House of People may be removed from his or her office by a resolution of the House of People passed by a majority of all the, see here, this is the catch. It says then members of the House. What is then members of the House? Okay. Provide that no resolution shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Okay. Come to the explanation part. Okay. So obviously the Speaker does not vacate his office immediately after dissolution. He waits because Speaker is a continuous institution. He waits until the next house. First sitting of next house happens. Okay. So first is correct. Come here. In Britain, there is a provision that the Speaker will resign from the political party. Okay. But in India, there is no such provision of resigning from the political party. He continues to be the member of the same political party like he is elected. Okay. So, and third thing is, Speaker can be removed by an effective majority. What is effective majority? Effective and then majorities are same. Effective majority is, suppose if there are 540 seats and 40 are vacant. So the effective majority or then majority will be 500. So how many votes he has to get? 250. 250. Okay. And 14-day notice has to be served to him. Okay. So third is also correct. So the option will be 1 and 3. Okay. 2 will be wrong. He need not. Okay. Come now. The 8th question. If any question arises as to whether a member of House of People has become subject to disqualification under the 10th schedule, who shall take a decision? It says the President decision in accordance with the opinion of Council of Union Ministers shall be final. Okay, we'll see. Second thing is, there is no mention of the word political party in the Constitution of India. No mention of word political party in the Constitution of India. Come to the explanation. Who decides the 10th schedule? It is Speaker. Speaker will decide the petitions under 10th schedule of the Constitution. Okay. See, the Speaker of the respective house acts as quasi-judicial tribunal to adjudicate disqualification petitions. Again, a happening news, but basic question. Okay. Come down. 10th schedule of Constitution, which is anti-deflection, or uses the term political party. See, originally in the original Constitution, there is no mention of political party maybe. But see, what has 10th schedule added? 10th schedule spoke about defection. And where do you defect from? You defect from a political party. Hence, the Constitution contains the word political party. Okay, and come now. See, this I have taken it from the exact Act 1985 10th schedule, and it says original political party. That means political party is mentioned in the Constitution. Okay, so what will be the answer? The answer will be neither 1 and 2. Neither 1 and 2. Okay, come now. Consider the following statement. 69th question. Consider the following statements. Statement 1. In India, state governments have no power for making rules for grant of concession in respect of extraction of minor minerals, even though such minerals are located in their territories. So it says, even when the minerals are located in their respective territories, state government cannot make laws for the grant of concession. Okay. Second will be, in India, the central government has the power to notify minor minerals under the relevant law, and law is also not said. Okay, it says central government can notify minor minerals under the relevant law. Okay, so which one of the following is correct? So come down to the explanation. So the explanation states state government can definitely grant concessions. And who notifies minor minerals? Union government notifies the minerals as minor minerals. Okay, so come here. Governments in India have the authority. Which governments? State governments. Grant of minor mineral concessions. And where do they get this power from? From the Mines and Minerals Development and Regulations Act 1957. Mines and Minerals Development and Regulation Act 1957. Okay, and what can they cover? They can cover various aspects like application process, fees, and how applications are acknowledged, and what all. Okay, come down. Central government has authority to define and declare what constitutes a minor mineral. Who has power? Central government. Okay, so, and what are minor minerals? Gravels, building stones, okay, clay. These can all be called as minor minerals. Okay, so the answer will be, this will be wrong and this will be correct. So statement 1 is incorrect and statement 2 is correct. So 1 is incorrect and statement 2 is correct. Come to the next question. Okay, 81st question. It says, with reference to Indian polity, consider the following statements. Consider the following statements. What? An ordinance can amend an central act. Okay. He says an ordinance can amend any central act. Okay. Come down. An ordinance can abridge a fundamental right. Okay. Ordinance can abridge a fundamental right. Third thing, an ordinance can come into effect from a backdate. And what is something which affects from backdate is called a retrospective act or retrospective law. Okay. Now we'll see the options. Okay. Ordinance in all its powers and effects has the same thing as a law, is equal to a law. Only thing is, when a law is passed, it contains until it is repealed or is struck down by a court of law. But in case of ordinance, it is only valid, its maximum lifetime can be 6 months, 6 months and 6 weeks. 6 months plus 6 weeks. Why? Because ordinance has to be approved by the parliament within 6 weeks after its sitting. Okay. Only difference is that unless that everything in ordinance and act are same. Okay. So yes, ordinance can amend any central act. Okay. Come down. Ordinance cannot abridge a fundamental right. Ordinance is not a constitutional amendment. And in various judgments, what you have found is once you have to take away any fundamental right or restrict a fundamental right, what do you need? You need a constitutional amendment act. So our ordinance is never a constitutional amendment act. So it cannot abridge a fundamental right because it will be violative of Article 13 of the Constitution and it will be stuck under judicial review. Okay. So fundamental rights cannot be abridged by ways of ordinance. Clear? Okay. Come to the third option. Yes, ordinance can be made to have a retrospective effect. As I told you, it is no different from the law unless only in case of time period it is different. Baki, it is all same. Okay. So ordinance can be retrospective. Ordinance can be retrospective, which means it can enact it to take effect from a date before its promulgation. Clear? Okay. So the answer will be 1 and 3 only. 2 will be wrong. To the next question. 82nd question. Interesting question. A factual question. And it says Arunachal Pradesh, 3 states are given and they are being described. Okay. They are being described. We'll go one by one. They speak about Arunachal Pradesh and they say the capital will be Itanagar. So he says capital is named after a fort. Okay. And state has 2 national parks. State has how many national parks? 2 national parks. Okay. Nagaland. The state came into existence on the basis of a Constitutional Amendment Act. Initial, and then we speak about Tripura, and they say it's initially a Part C state. What is a Part C state? Part C states are those states which are administered by Chief Provincial Commissioner. Okay. It became a centrally administered territory with the reorganization of states in 1956 and later attained the status of a full-fledged state. See, it has asked you a chronology of events which has happened with the northeastern states. Okay, come to the explanation. Obviously, Itanagar, eat. If anybody can comprehend, what is eat? Eat is a brick. So, yes, it's a 14th or 15th century fort from which the capital city of Arunachal Pradesh, Itanagar, derives its name from. And yes, it has 2 national parks. Namdapha National Park, very famous, and Mauling National Park. Okay. Come to the second option. Second option was about Nagaland. Nagaland was formed through 13th Constitutional Amendment Act. 13th Amendment to the Indian Constitution made the state of Nagaland. And why was it Constitutional Amendment? It was because there were special provisions granted to Nagaland. Special provisions granted to Nagaland through Article 371A. 371A. Okay. And third option, Tripura became a Part C state. First, Tripura was a Part C state. Okay. When it merged in India with 1949. When it merged with India in 1949, it was a Part C state and then become a union territory in 1956 under the States Reorganization Act of 1956. Okay. And then again, it was given a full-fledged statehood again when it was in 1972. 1972. Come back to the question. So, all three options will be correct. All three options will be correct. Clear? Hopefully. Come here. With reference to India, consider the following. Okay. And he gave three options. One is the Interstate Council. One is the Interstate Council. The second one is National Security Council. Second one is National Security Council. And third one is Zonal Council. Zonal Councils. And he says, how many of the above were established as per the provisions of Constitutions of India? As per the provisions of Constitution of India. So, see the difference? ISC, Interstate Council, you know, is formed by Article 263 of Constitution. 263 of Indian Constitution. It's a non-permanent yet a constitutional body. Yet a constitutional body. It is always in use. Yeah. Okay. Come to the second option. NSC, National Security Council, is an advisory and an executive body. It is an executive body, not a constitutional body. Okay. Advisory and executive body and not a constitutional body. Okay. Come now to the third option. Zonal councils are again not constitutional bodies. They are statutory bodies. See, they are statutory bodies. That means they were formed by an act of parliament. And which act is it? SRC of 1956. Two questions. One is here. The other on SRC was in the previous question as well. Okay. So the answer will be only one, which is Interstate Council. Interstate Council. Clear? See, it just needs you to have some basic conceptual knowledge and be very aware at the time of answering these questions. Okay? You can easily eliminate National Security Council because it itself says a council. Okay? See, again, it is given to trick you. But you know, National Security Advisor is not a constitutional body. Okay? Hello? See, a tricky question here. Usually what happens when we see explicitly? When we see explicitly, we deem the option to be wrong. We deem it to be wrong. But what happened here? See, the Constitution of India explicitly mentions those. What does explicitly mean? That the provision should be very clear in the Constitution of India. Okay. So, in certain spheres, the governor of a state acts in his or her own discretion. So, it says, constitutional discretion has been clearly provided to governor by the Constitution of India. Okay. Come to the second one. President of India can, okay, his or her own reserve a bill passed by state legislature for his or her consideration without it being forwarded by governor of the state concerned. Okay. Okay. Come now. So what can be the answer? So usually what we feel is one will go wrong, two will obviously go wrong because governor has to forward it. But see, there's a twist in the tail. Twist in the tail because yes, the governor has been provided discretionary powers. He has situational discretion and constitutional discretion also. When does he have situational discretion? Situational discretion is when, see, suppose there is a no majority thing in the assembly elections. So he has discretion to call which party makes a coalition or something. That sort of powers are called discretionary powers. Okay. Come to constitutional powers now. See, governor of states can act at their constitutional discretion in the following, and it is clearly mentioned. See, I've given an example also from Article 200. You can see here, when they have to reserve the bill for consideration of the President of India, Article 200E, in the opinion of the governor. What does it state? In the opinion of the governor. That means constitutional discretion. Clear? Constitutional discretion. Okay, come down. And in the second thing, okay, the second thing will be, okay, and when he has to recommend for president rule in the state, again a constitutional discretion. Okay, come down. He's given an additional charge as administrator. Then also he possesses constitutional discretion. Okay, come down, and he has to determine the amount payable by government of Assam, Meghalaya, Tripura and Mizoram to ATDCs, autonomous tribal district councils. And these are explicitly provided in the constitution. So yes, a governor has constitutional discretions explicitly mentioned, again in some spheres, as he mentioned, in some spheres. Okay, come down. And second, no, the president cannot reserve a state bill without the governor. It is nowhere mentioned that president can directly take up a state bill for his consideration. It has to be done through the institution of governor only. Through the institution of governor only. Okay, so the answer will be one only. One only. Yes, the constitution explicitly mentions that in certain spheres, this is the catch here, in certain spheres, yes, in certain spheres, the constitution provides a discretion to the institution of government. Okay, clear? Come to the next question, 85. Simple question, it's an easy catch. Okay, so it says separation of judiciary from the executive. Previous year question, I think 2020. Okay, yes, it is a directive principle of state policy. It is a directive principle of state policy. Come down. Valuing and preserving the rich heritage of our composite culture. Fundamental duty. Okay, fundamental duty. The third is prohibition of employment of children below age of 14 years in factories. It's a fundamental right. Come to the explanation. I want to watch it once. Okay, see, Article 50 DPSP. It says, see, state shall take steps to separate the judiciary from executive within the public services of the state. Within the public services of the state. Exact words mentioned and picked up from your bare act of the Constitution. Okay, come here. Valuing and preserving a rich composite heritage is a fundamental duty for citizens of India, as enshrined in 51A(f) of the Constitution. 51A(f) of the Constitution. So the usual pattern, a question on fundamental right and fundamental duties. Okay, come down. Article 24 of Constitution prohibits the employment of children below age of 14 in factories. He stopped till here. So all three will be. So the option will be, see, all the three are correct. Okay. Consider the following statements. Okay. With reference to Constitution of India, if an area in a state is declared a scheduled area under the 5th schedule, if an area in a state is declared as scheduled area under the 5th schedule, so what happens? See, the state government loses its executive power in such areas and local body assumes See, the catch here is, yes, the state government might lose some power because it devolves some of the powers to the local governments. That is fine. But see, loses total administration. Take for example of Telangana. There are scheduled areas in Adlabad also. The state not functioning there? No, state will function. It will not. It is not going to give up total administration. Okay, and come down. The union government can take over the total administration. Okay, of such areas under certain circumstances and the recommendations of the governor. Okay, so we'll see the answer. Come to the explanation. The explanation says, the fifth schedule of the constitution, obviously what is it? Outlines provisions for administration and control of scheduled areas and scheduled tribes in the states other than Assam, Meghalaya, Tripura and Mizoram. Assam, Meghalaya, Tripura and Mizoram. Okay, and come down. The state government's ability to enact and enforce laws in scheduled areas is obviously restricted. It is restricted. That's a given thing. It is definitely restricted by the governor's powers and the president elections. But however, local body does not assume total administration. It says local body assumes administration is what he asked in the question. It does not assume total administration. No. Okay. Come to the second one. No, and union government cannot take over the administration. Union government cannot take over the administration of the fifth schedule area based solely on a governor's recommendation. See? While, how is the center role? Center role is to tend the directions to the state government. It is to provide directions to the state government. Provide directions to the state government. Okay. The executive power of union shall extend to giving of directions to the state. Shall extend to giving of the directions to the state. It's again picked up from your Bayer Act. Okay. This statement is also picked up from your Bayer Act. Okay. 80. So the answer for the previous question will be neither one nor two. Neither one nor two. Clear? Okay. With reference to India, consider the following pairs. Consider the following pairs. 87th question. Okay. The National Automotive Board. The National Automotive. Pure factual question. You can use some brains. You can use. But it's a purely factual question. Okay. And see, the COIR board, he says it functions under the Ministry of MSMEs. Okay. The National Center for Trade Information functions under Ministry of Commerce and Industry. Okay. We go to the explanation and see. See, the National Automotive Board is under Ministry of Heavy Industries and Public Enterprise. It functions under Ministry of Heavy Industries and Public Enterprises. Okay. And come now. COIR board is under MSMEs. Yes. Is under MSME Ministry only. Okay. Come now. NCTI, National Center for Trade Information, is under Ministry of Commerce and Industry. Ministry of Commerce and Industry. So what will be the answer? Your factual question. Can't do much about it. Sorry for the mistake here. The answer is all the three. The answer is all the three are correctly matched. All the three are correctly matched. Automotive Board under Ministry of Heavy Industries and COIR board under Ministry of MSMEs and National Center for Trade Information under Ministry of Commerce and Industry. Go to the next question. The question is 88. 88. See the question. Consider the following subjects under the Constitution of India. Okay. See, list 1 is Union List in the 7th schedule. Okay. Union List in the 7th schedule. Okay. So there are 3 lists: Union List, State List, and a concurrent list. So you see, he gave an option of Union List. Okay, we'll just see. Extent of executive power of the state. Probably State List. Okay. So how much can state government make laws on? Or the ambit of power of state government? Okay. Come to the third one. Conditions of the governor's office. What is it? conditions of the governor's office. And what is the question? For a constitutional amendment with respect to which of the above ratification by legislature of not less than one of the states is required? You know how many types of majorities are there? Okay, effective majority, special majority, simple majority, and a special majority combined with ratification by half of the states. Okay, you know all those things. GST was one such thing. So, how many of these things, how many of these lists, if you want to make an amendment on, require half state ratification? Chalo, come to the explanation. See, obviously, anything which affects the federal structure, federal institutional structure of country needs a constitutional amendment and ratification by half of the states. So obviously, in the first case, affecting union list, okay, they touch upon this distribution of legislatory powers between union and states. They touch upon the distribution of powers between union and states. Hence, they require ratification by at least half of state legislatures. They require ratification by half of state legislatures. Okay, come down. Okay. And the second thing, what was it? Okay. Executive power of the state. The second option, executive power of the state. Okay, that is also affecting your federal structure. Okay, that will also require ratification. Requires ratification by at least half of state legislatures. Come to the third one. Third is a little bit catchy thing. Okay, see, I searched the 7th Constitutional Amendment Bill. Okay, in 7th Constitutional Amendment Bill, the provisions of governor were changed. Okay, the third option was provisions of governor. No? So the provisions of governor was changed in 7th Constitutional Amendment of 1956. And what did it do? 7th Constitutional Amendment of 1956 said one governor can also be governor for 2 states. Okay, that was being done. And did it go for ratification by half of the states? No, it did not. No, it did not. And it also amended provisions of the governor. So, provisions of governor does not require ratification by half of the states. There is an example to it, which is 7th Constitutional Amendment Act of 1956. Okay, so obviously the answer will be 1 and 3 only. The answer will be 1 and 3 only. Clear? Okay. Huh. 89th question. With reference to Indian polity, consider the following statements. And what are the statements? The governor of a state is not answerable to any court for the exercise and performance of the powers and duties of his or her office. Again, see the questions on president, the questions on governor, the questions on speaker, the questions on Lokpal. See everything and anything in news, but have to go a layer deep. So now see the answer. So it says governor of state is not answerable to any court. Okay, for the exercise and performance of the powers and duties of his or her office. Okay, judicial immunity. Okay, come down. No criminal proceedings shall be instituted or continued against the governor during his term of office. A PYQ. A PYQ. Okay, come down. Third one. Members of state legislature are not liable to any proceedings in any court in respect of anything said within the house. Okay, three things. Judicial privileges and member privileges are mixed to make a question. Okay, so 3 things. Talk about your judicial immunity. Okay, come down. Let's see the explanation. The explanation will be, yes, it is mentioned in your constitution. See, the president or the governor or Raj Pramukh of a state shall not be answerable to any court for the exercise and performance of the powers and duties of his office or for any act done on purporting to be done by him in the exercise and performance of those powers and duties. So is he liable? No, he is not. Clearly mentioned. No ambiguity. Okay. Second option, no criminal proceedings whatsoever. No criminal proceedings whatsoever, okay, shall be instituted or continued against the president, okay, or the governor of a state in any court during his term of office. No proceedings. Okay. So next, and Article 194 of the Constitution of India. See, again, what does it state? The House of Legislatures and the members on committees thereof, okay, and no member of the legislature or the committee shall be liable to any proceedings in any court in respect to anything said or any vote given by him in the legislature or any committee there. Okay, nobody is liable. So the answer will be 1, 2, and 3, and it is an exact copy of a previous year question. Exact copy of a previous year question. Okay. Question number 90. Consider the following activities. Okay. See, production of crude oil. Okay. Refining, storage, and distribution of petroleum. Refining, storage, and distribution of petroleum. Third, marketing and sale of petroleum products. Fourth is production of natural gas. How many of above activities are regulated by Petroleum and Natural Gas Regulatory Board? Simple thing. Do you have enough resources for production of natural gas or for production of what do you call crude oil? No, these are imported things. They are processed, distributed, and marketed by Petroleum and Natural Gas Regulatory Board. It is not concerned with the production. When you go to the Act, okay, the Petroleum and Natural Gas Regulatory Board Act, okay, it itself says has been mandated to regulate the refining, processing, storage, transportation, distribution, marketing, and sale of petroleum products and natural gas. See, excluding production of crude oil and natural gas. So it does not do the duty of production of crude and natural gas. Okay. So regulated will be 2, 3. So only 2 will be your answer. Only 2 will be your answer. Okay. Okay. We are done with the polity. We'll come to a simpler topic, international relations. Hopefully it's simpler. Okay. So consider the following countries. Consider the following countries. See, again a NATO question. So much of news because of the Russia-Ukraine war. Okay. Ukraine wants to be a part of NATO, and Russia will not like NATO members to be in its neighborhood or its vicinity. So again a NATO question. Since years there has been a question surrounding this Russia, Ukraine, NATO things. Okay. Okay. So which of the following countries are part of NATO? What are not? Serbia is not, and Austria is not. So four countries are part of North Atlantic Treaty organizations. Which are they? Bulgaria, Croatia, Sweden, and North Macedonia. Okay. 2 are not there. Which are not? Serbia is not a member of NATO, and Austria is also not a member of NATO. Okay. Come down. Okay. Okay. There is a question here itself, 52nd question. Consider the following statements in respect of BIMSTEC. In respect of BIMSTEC. Okay. And it says it's a regional organization. Okay. Consisting of 7 member states till January 2025. 7 members till January 2025. You know a simple mnemonic? 1, 2, 3, 4, 5, 6, 7. Okay. Next, come down. It came into existence with signing of Dhaka Declaration 1999. Okay, it's another fact. Is it Dhaka Declaration? We'll see. Okay. Come to the third option. Bangladesh, India, Sri Lanka, Thailand, and Nepal are founding member states of BIMSTEC. India is definitely. Bangladesh is also is. But is Nepal a founding member? Okay, you'll see. Yes. Explanation here. Okay. The thing is, yes, it is 7 member states only. No admissions has been made. Okay. It still remains a 7 member body. That's a correct option. Okay. But come down, it is not Dhaka declaration, but Bangkok declaration. It is not Dhaka declaration, but Bangkok declaration. So statement 2 will be wrong. And third one, Bangladesh, India, Sri Lanka, Thailand is correct. But Nepal is not a founding member. Okay, Nepal joined later, but is not a founding member state of BIMSTEC. So only one option is correct there. So it is first one and the fourth one. See, in BIMSTEC, the subsector of tourism is being led by India. Correct. Okay, the first option is correct and the fourth option is correct. Okay. In BIMSTEC, there are different sectors arranged priority wise, and which tourism sector is held by India. Okay, it's a correct thing. Okay, so the answer will be 1 and 4. The answer will be 1 and 4. Okay, so it's just tweaked. See, it's just tweaked Bangkok declaration with Dhaka declaration. Just a simple thing. Okay, okay. 55th question. Consider the following statements regarding AI Action Summit and Garland Palace. Okay, where was it held? He himself says Paris. Okay, and the option A says co-chaired with India. The event builds on the advances made at Bletchley Park Summit held in 2023 and Seoul Summit held in 2024. Correct. Okay, it is a continuation. It takes from where these two have left. Bletchley Park Summit and Seoul Summit. Okay, the option 1 is correct, and it was co-chaired with India. Okay, the second option, along with other countries, US and UK signed the declaration. Okay, on inclusive and sustainable. US and UK actually have refused to sign the declaration. They refused to sign the declaration. Clear? Okay, they refused to sign the declaration. So only first option will be correct. First option will be correct. Clear? Okay. Okay. 57th question. Okay. Come here. Consider the following statement with regards to BRICS. Again, see, very basic. BRICS, BIMSTEC. BRICS, BIMSTEC. Leave that AI Action Summit. And that was also in news because US and UK refused to sign that AI Action Summit is the headline. Okay. There were articles written on that thing. Okay. Hello, come here. 16th BRICS Summit was held under the chairmanship of Russia in Kazan. Yes, correct. 16th was held in Russia under the chairmanship of Russia in Kazan. Okay, and Indonesia has become a full member of BRICS. Okay, it says Indonesia has become a full member of BRICS. Theme of correct. Indonesia has become a full member of BRICS. And the third thing. Okay. The third thing, the theme of 16th BRICS Summit was strengthening multiculturalism for just global development and security. See, he just tweaked here. Okay, that is wrong. In place of multilateralism, he gave multiculturalism. So that goes wrong. UPSC wordplay. Generally, themes in UPSC are wrong. and he kept that trend intact here. So it should have been multilateralism and not multiculturalism. Okay, so option A, 1 and 2 will be correct. 1 and 2 will be correct and 3 will be wrong because he tweaked the word there. 38th question. India is one of the founding members of International North-South Transport Corridor, a multimodal transport corridor which will connect what? India to Europe, Azerbaijan. India to Europe through Azerbaijan. Okay, clear? That's it. That will be my polity and IR questions. Hopefully, you make to the cutoff. If you have are getting somewhere around 85 or 90, please start preparing immediately, because you have seen 3 keys were ambiguous and you never know you'll be in cutoff or not. Please start preparing. There is not much time for this mains. So all the best, everyone. Please start your preparation and hopefully make your way through in the final list. Thank you so much.